The U.S. Bill of Rights, which contains the first 10 amendments to the U.S. Constitution, specifies a number of personal liberties that are protected and places constraints on the national government. For instance, the First Amendment declares that, quote, Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people peaceably to assemble, and to petition the government for a redress of grievances, end quote. This is probably the most famous of the amendments, because there's a lot packed into it, and it includes well-known liberties, such as the freedom of religion and the freedom of speech. Notice, however, who the First Amendment is referencing. The first word in the amendment is Congress. That is, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, and so on. In fact, all of the amendments in the Bill of Rights are placing limits on and guaranteeing freedoms relative to the federal government. This is very important. The protections contained in the Bill of Rights did not apply to the state governments. In other words, Congress cannot establish a religion, but who's to say a state couldn't? Congress can't prohibit the free exercise of religion or the freedom of speech, but what is to stop a state from doing so? Nothing, at least not originally. That's because the Constitution primarily centers on the power of the central government, what we call the federal government. Without the Constitution, there would be no central government, at least not as we understand it today. But there would be state governments because they existed already. So, when the Bill of Rights was added to the Constitution, in similar form it was speaking about the central government, not the state governments. This was made clear in the 1833 case, Barron v. Baltimore, in which the Supreme Court ruled that the amendments in the Bill of Rights only applied to the federal government, not to the state governments. Accordingly, nothing would prevent state governments from violating the rights contained in the Bill of Rights unless their own state constitutions contained similar protections. Now, the reality is, state constitutions do contain similar protections, and often even more. But absent that, does that mean, at least in theory, that a state could violate your freedom of religion or freedom of speech? The answer was yes, until the 14th Amendment came along. The 14th Amendment is a comprehensive amendment that came about as a result of the Civil War and contains a number of important clauses. One of those clauses is a due process clause. The importance of the 14th Amendment's due process clause is that it has been interpreted as applying the Bill of Rights to the states. This is known as incorporation of the Bill of Rights, or the Incoporation doctrine. The incorporation of the Bill of Rights to the states did not happen all at once, however, nor is application of the Bill of Rights to the states complete. The Supreme Court began incorporating these rights to the states beginning with the Quincy Railways v. Chicago case in 1897. As of today, through numerous cases, almost all of the Bill of Rights provisions have been incorporated to the states through numerous cases that the Supreme Court has ruled on since the Quincy Railways case. To help you better understand how this doctrine of incorporation works, let me illustrate using a hypothetical lawsuit. Let's say the federal government passes a law that you believe violates your freedom of speech. You could sue the federal government in federal court and make your case that the law violates your First Amendment rights. But what if your state passed an equivalent law, one that you thought violated your freedom of speech? Well, before the 14th Amendment, there may be nothing you could do unless your state constitution included a freedom of speech protection. Today, however, you could sue your state in federal court accusing it of violating the 14th Amendment, which applies the freedom of speech guaranteed in the First Amendment to your state. That's the incorporation doctrine in action. In other words, your state is on the hook for the First Amendment because of the 14th Amendment. Thus, your case against the state would be accusing them of violating both the 14th and First Amendments, whereas your case against the federal government would only involve the First Amendment. Now, it is important to note that historians do not all agree that those who crafted the 14th Amendment in the 1860s intended it to be used to incorporate the Bill of Rights to the states. But historians are not the ones making judicial decisions. That power rests with the court. And the court has made it very clear over the last century that the Bill of Rights applies to the states thanks to the doctrine of incorporation established by the Due Process Clause of the 14th Amendment.